The purpose of this podcast is to educate and inform. It does not provide legal advice. It does not create an attorney-client relationship. While the host is not a lawyer, the content is overseen by licensed counsel. If you need help with a legal matter, you should always consult with a qualified attorney.
Foreign trained professionals, especially physicians, are an essential part of the U.S. healthcare system. And right now, we're seeing legislative efforts here in Texas that are opening the door to create more pathways for them to practice. But with that opportunity comes a critical reality. Being qualified to practice is not the same as being authorized to practice. This is Know Your Regulator. I'm your host, Simone Murphy, and today we're talking about where immigration law and professional licensing intersect. We're diving into how misunderstandings in that overlap can lead to some serious consequences, from board complaints or investigations to immigration status issues. My guests today both have a wealth of experience in their fields. I'm joined by immigration attorney and founder of the Amell Law Firm, JJ Amell, and professional licensed defense attorney and director of legal services at the Bertolino Law Firm, Troy Beaulieu. Thank you both for joining me.
Good afternoon,
Pleasure.
Simone. Glad to be here.
Well, we are hearing a lot more about flexibility for foreign trained physicians. JJ, can you talk to us a little bit about those pathways that are being expanded, and what should professionals understand about these opportunities?
Sure. JJML with Amell Law. We're based in Houston, Texas, and we help professionals enter the U.S. market. And we're starting to see some reforms in a number of states. The demand for physicians is getting better and better, and or more open, and the restrictions are becoming less and less. Texas being one of them. We're starting to see reforms in other states, and it's just the overall what we've seen in the past is that physicians had to go through almost go through retraining. They were coming from abroad, they've already done their specializations, their fellowships and residency, and um, we're starting to see some lacks in the United States because the demand of physicians are is greater now. And so it's encouraging to see that. And from an immigration perspective, that's really encouraging because these physicians or healthcare professionals have to be licensed so they qualify for their various types of visas. So I'm happy to see that this reform is occurring.
Yeah, absolutely. Troy, from a licensing perspective, what are the most common misunderstandings that you are seeing from foreign trained professionals?
Yeah, absolutely, Simone. Great question. So, what we're seeing on the licensing, the regulatory side, is people coming with the assumption or the expectation that all of their training and experience is going to automatically translate into the regulatory scheme here in Texas. And that is not always the case. I've had a number of clients who are very well qualified, very knowledgeable, long-standing practitioners in their field, but their educational background or their examination or specific requirements are different because they're coming from a different country. Not any less competent, but just different. And the state does not have, many times the agency doesn't have the discretion under the law that's passed by the legislature, which only meets every 2 years, to do something different. So a lot of times you have a situation where there's a round peg and your client may be, a square peg and not able to fit into those legislative parameters. So we have seen on, like JJ was alluding to, very positive change in that. The legislature recently passed House Bill 2038, which amends Chapter 155 of the Texas Occupations Code specifically to foreign trained physicians and gives more flexibility for them to be able to come in and be sponsored by a physician who's already licensed here, and gives them greater flexibility to allow that to happen. But it's definitely a common misconception that, hey, I can just come here and be able to get the license that I need. And you find out, oh, there might be some roadblocks to that.
And
Yeah.
if I may add to Troy's point, from an immigration standpoint, it's extremely frustrating for physicians who have extended years of experience, uh, not being able to enter the U.S. market. They want, they want to live the American dream, right? Um, but because of state regulation, licensing restrictions, they're not able to do so. Even though we have this demand, in particular case I'm thinking of, is for physicians. We have a great demand for physicians, um, but it's just very encouraging to see that legislation is looking to reform again, because many of these physicians are highly qualified, even more qualified when compared to physicians that have been working, that are working now.
Right. Yeah, no, and it really sounds like as the doors open that the expectations around qualifications and compliance are not necessarily changed, they're just navigated differently.
And if I may add to that, Simone, when we uh, apply for a particular visa for a physician or a client, each visa has a specific intention.
Mhm.
And we have to make sure that we're qualifying that particular person with that intention, but also bearing in mind where they're going to live, right?
Yeah.
We know that healthcare, law, CPAs, these are highly regulated sectors or industries, right? By state government. So we have to make sure not only from a federal perspective that we're staying consistent, but also being consistent from a state perspective.
Yeah. It's those dualities, you've got both going on at the same time. Both are kind of have a hand in this. So, let's talk
Absolutely.
about what happens when someone practices or even begins working and they don't have the proper credentials. Troy, what are we looking at here? What happens?
Yeah, that's a great point, Simone. And unfortunately, I have seen people who have particular immigration status run into this issue. And it can be very concerning for that special niche population more than the general population, right? So, not having a proper valid license exposes you to a lot of legal risks. It is illegal in Texas for most credentialed licensed professional fields to be operating without that state specific license. It typically is a crime in Texas. It's a low level crime. It's a misdemeanor, but it's still a crime. And it also violates various state laws and regulatory provisions. And so you can be faced with a lot of legal consequences if you've accidentally let your license lapse, if you've failed to complete timely continuing education, and as a result, your license becomes inactive. If you get a complaint that where your license is temporarily or permanently suspended or revoked, so it's really important to understand the dynamics of what's going on with your license in front of your regulatory agency and how that relates to your status on the immigration side, which I'm sure JJ has some unique perspective on.
Yes, and great point, Troy. One of the things that we have to vet as immigration attorneys is, a client's background, right? And unauthorized practice of medicine or law, these can be hindrances um, uh, to obtaining a particular type of visa. And so we have to carefully vet, but also carefully answer those questions that the federal government wants to know about our client's background. And we never want to hide anything, of course, but we want to be careful about how we answer things and make sure that, in the case of, unauthorized practice, that is remedied. We want to make sure that we can create as clean as possible an immigration history that does not hinder uh, the ability to obtain state licenses like such as veterinarians or physician licenses.
Yeah, it sounds like really that one issue with the licensing board can really kind of create a domino effect, or maybe, for lack of a better analogy, sort of a ping pong kind of going back and forth and back and forth. Um, can you guys talk to us about kind of how that plays out across both systems and how they work together? Troy, let's start with, say, a foreign trained professional receives a licensing complaint?
Yeah, Simone, it really is disconcerting for anyone who has a license, but it has some added dimensions and concerns for people who are here on a visa and are not citizens. So you get that complaint, and there might be some serious allegations. Those allegations could suggest criminal misconduct. They could suggest, like we said earlier, unlicensed activity, or just other violations of the law or breaches of ethics that could support suspending your license, revoking it, or making a referral to a law enforcement agency for a criminal investigation. Any one of those three things obviously have repercussions in the immigration world, because your your status here, as I'm sure JJ can explain more, is often tied to your ability to do your job in your particular profession. So if you get an emergency suspension of your license, for example, because of some very serious allegations, you're not allowed to practice. If your license is revoked and you lose that ability, if you're now under investigation or you've had to address allegations of conduct that is essentially criminal in nature, those all have reverberations in JJ's world as an immigration attorney.
Thank you for that, Troy. That's, I mean, excellent points. And we have to be very strategic when, let's suppose you have someone who is once licensed here and their visa is contingent on that license. You know, the question we have to ask is, do, does the visa become revocable at that point? Right? Because
Mm-hmm.
as I shared earlier, and I want to emphasize here, every visa that we have has an intention, right? And if it's an employment-based visa, and the employment is and the employer discharges the employee because they can no longer work, does the visa become revocable? And now we're in a bit of a flex situation. And so we have to be very strategic. We have to work with strategic partners, strategic lawyers like Troy, to make sure we can remedy the situation. Or do we have to change the visas, the type of visas, so that the person can appropriately challenge uh, the issues regarding the temporary uh, revocation of their license, their ability to work.
Mm-hmm.
So we're dealing with quite a number of issues, a lot of timing, and it can be very distressful for a client that may have had a false accusation. Yeah, so it can be tough. It can be
Right.
very tough.
You still have to
And
enter that process, you still have to go through that process, but it can have those consequences, and it sounds like things can escalate pretty quickly when you've got the 2 systems that, are very much connected, but they're totally separate. So, I can
Hmm.
see that would be really stressful, it's costly, there's a lot of uncertainty there, but surely there can be, some prevention done to avoid experiencing these issues. So, let's talk about identifying these points and putting some preventative action in place. Troy, what would you say are the most common compliance breakdowns that you are seeing individuals experience on the licensing side?
yeah, Simone. So one thing that is new and that we're seeing a big Texas push on, that everyone who's affected by these issues needs to be aware of, is these right to work requirements. The Texas Attorney General recently issued a new opinion, Ken Paxton, in February of this year, that state agencies have to document, and applicants have to provide proof when they're applying and when they're renewing for their license, that they have the right to work based on certain documents. The Texas Department of Licensing and Regulation is currently considering rules to that effect that are scheduled to go into effect in May. Even the Texas Medical Board legislation I mentioned earlier, House Bill 2038, while it expands opportunities for foreign trained physicians, it too has language in there saying that you have to demonstrate that you're lawfully in the United States and you have the right to work. So that's one issue that is now we're seeing. We're getting new clients who are having this issue. The second thing I would say is, either a complaint, um, implicating their ability to continue practicing if they get an emergency suspension of their license, if they're facing disciplinary action where their license may be suspended or revoked, or if again, there's some question about do they have a license, are they authorized to practice to begin with? All of those things are going to be issues that JJ and other immigration lawyers are going to be having to confront as well, because they implicate your ability to continue on practicing, whether it's accounting or engineering or being a physician or a veterinarian, whatever your field is. And this is a statewide issue because it's not just, well, I just named a few of those state agencies. It is statewide now, an expectation based on this Attorney General opinion.
And to add to what Troy just said, the way I like to describe our immigration process is, what? Let me back up. There's confusion about employment-based work or employment-based visas and non-immigrant visas, and I want to quickly explain the two. The way I describe it is like it's like a school. You have one school that is non-immigrant based, and you have another that is immigrant based. And immigrant, the word immigrant really is a legal term, and it translates into green card or permanent resident. All right. Now there are certain types of work visas that allow for a person to work for a period of time for a specific purpose. All right. Now, there's the other school, the immigrant school. It means that this person is becoming a permanent resident, and permanent residency or a green card allows that person to work. Many times we'll start with an immigrant on the immigrant non-immigrant side, get them here, uh, and then transfer them over to the immigrant school. And touching on the point of authorization to work, let's suppose you have someone from Mexico and there's a subsidiary company here in the United States. That person is becoming an intercompany transferee. That's an L1 visa. The L1 visa automatically, once approved, allows them to work, and they'll put a stamp on their passport, and that's proof of authorization to work. Where in the case of permanent residency, their green card is enough to show that they're able to work. Now, to put it in context that we know, our U.S. for U.S. citizens, U.S. passport's fine, Social Security number is fine. That's proof of lawful ability to work.
Yeah. Are you seeing any sort of administrative or procedural failures, JJ, on the immigration side of things that can cause problems for individuals?
Well, the biggest problem is time delay.
Mhm.
And most of the time, we have to recommend to our clients premium processing, and that allows us to accelerate the ability to obtain the visa or to do a change of status. All right. Um, I think one of the frustrating things is people who are refugees or asylees, and they're trying to get an employment authorization document. It can take it can take them time to renew.
Mhm.
So, for example, um, it's not. It used to be more so that you had to renew your employment authorization document, and it would be like in a kind of in a gray area until
Mhm.
you would apply for renewal, and you were in this gray area that it was still good. Now we're not
Yeah.
starting to see that so much, that you're having to the renewal process is becoming kind of questionable, and
Mhm.
yeah, we're seeing a lot of change there, and it's concerning to our clients. Um, it's just becoming very concerning to our clients.
Yeah, yeah, I'm sure. For employers too, who are hiring a lot of these foreign trained individuals, are very heavily tied into this too. What should employers or organizations be doing to assist these individuals and prevent issues for them and for their own organization or business?
Well, for those companies that regularly hire foreign individuals, I'm very much a proponent of getting educated on the front end of things. I don't, you know, a lot of times we see companies, it becomes an aftermath, or
Mhm.
the issue is already way down the line, and they said, "Oh, this is an immigration problem," and then it becomes very difficult to fix. So if a company is hiring one to several foreign individuals, it's good for the human resource department, the employer to get educated on what do we have to do to maintain this employee. And right now, as we're all aware, immigration law is changing consistently, almost day to day. So to be partnered up with an immigration attorney that can send out newsletters or frequent education newsletters, pamphlets, etc., I think is critical, and especially if you're hiring on a regular basis, you know, uh, foreign nationals.
Yeah, absolutely. And Troy, anything for, the licensing side of things that you'd like to add?
Absolutely, Simone. Businesses have a critical role in this process, and they need to be mindful that as part of their due diligence, they're making the appropriate license verification checks. You do not want to find out that you hired someone that doesn't have a license in Texas. You need to be tracking their renewal of their license, that it's done timely and that it hasn't lapsed. You need to be checking for their continuing education compliance, which can impact the active status of a license if it's not timely completed. And you need to avoid any accusations that you're aiding or abetting unlicensed activity, which could expose the company or individuals who hold licenses at that company at liability in front of the regulatory agency as well. And then, of course, you want to avoid any regulatory complaints against individuals at the company who may be in supervisory roles and have due diligence and legal obligations relating to supervising other types of license holders who are operating under their oversight. So again, there's a lot. There's a huge role for employers to play and the employees that they utilize in interacting with and managing and overseeing foreign trained professionals. And you want to be very careful so that you don't get drawn into some legal issues that expose the company and your other employees to liability.
And Troy, your point is so well received on this end, because immigration law is very different than the law that we're taught as a whole in law school. Innocent to proven guilty, right? Well, the burden is the opposite in immigration law. The burden is upon the person trying to receive the immigration benefit to prove that they're deserving of that. And an employer keeping track of CLEs, making sure that the person remains compliant, or is in regulatory compliance with uh, maintaining that license is critical, especially in the so. And when we go to renew these visas, we have to prove this up, and that is great evidence. I mean, if we have that evidence already, it helps us do our job better because of the burden that we have, right?
Absolutely. Couldn't agree more.
It just goes back to what you were saying earlier, JJ, that proactive mindset, putting things in place in the very beginning in the first place really helps you prevent, whether you're an individual or an employer or you're managing an organization, it helps you prevent those issues down the line. You've got some serious risk management that's already in place. So, as we come to a close, JJ, for a foreign trained professional who is listening right now, what would you say are the top things that they need to verify before they begin working?
Well, I think they first need to make. I would start with the employer first,
Hmm.
and so the employer needs to make sure that their candidate meets the licensing requirements. One, and then two, it's upon the the person to be sponsored or the future employee to help prove up with the employer and work as a team to prove up that they're deserving of these immigration benefits. And the best thing you can do is plan early and plan strategically, having a plan in place. And I encourage human resource departments to, if they haven't already done so, to have a strategy in place, an immigration strategy. And most of the times, human resources are already working with what we call the I-9, and that's really the lawful presence, showing lawful presence and the ability to work. It's incumbent upon human resource departments and their employers, or the employers, to prove that up.
Yeah. Troy, anything that you would say on the licensing side?
Yes, definitely. So you want to verify those credential requirements and confirm your licensure eligibility in Texas. You don't want to be getting down the road into this process and come to find out your education doesn't qualify, or the exam you took, or the experience that you have doesn't fit the particular regulatory scheme for that licensed profession. You've got to do your homework on that and not assume. I recommend people get legal advice early, get representation early, and be proactive, because you don't want these problems to grow and get out of hand. Make sure that your immigration and your licensed defense lawyers are coordinating, communicating, and collaborating, because there's two aspects to these situations, and you've got to get the professional expertise from both sides, right? I have a great dermatologist and I have a great brain surgeon, but I don't have my dermatologist do my brain surgery. And likewise, I wouldn't have my brain surgeon help me with issues with my skin. So again, having those experts in those two areas where there's crossover really becomes critical for you to get the best results in your particular legal situation.
Troy, may I add another point to your comments? Because I think everything
Absolutely.
is spot on. You know, one of the things we've been talking quite a bit about the employee side, but what about the, a little bit more on the employer side? Something that I think employers need to do on the regular is audit their employees, meaning like their ability to work. And
Mm-hmm.
what this is a very frequent problem, that when a person starts employment, they're okay, they're authorized to work, but they don't check annually that, oh, has that person maintained status, have the ability to work, so that person continues to work technically unauthorized, right? Or they could have lost their authorization, and the employer is not doing their due diligence to make sure, hey, everyone on our staff, are they able to work? So I want to encourage employers that are listening to this, do 6 month audits or one annual audits, and make sure that the people that are working for you are authorized to work, because there are fines and consequences to those businesses for
Yeah.
Couldn't
not
No,
agree
doing
very
more.
audit.
well said.
Yep.
Absolutely. As opportunity is expanding, that responsibility to understand the systems that you're operating in, how they operate with each other, it really heightens. So, JJ, Troy, thank you both very much for joining me and really diving into how these two areas of law intersect and how they impact each other, impact employers, organizations, and the individuals themselves. And to our listeners, whether you are a foreign trained professional or you're an attorney that's representing one, licensing and immigration, they do not operate in silos. And when something goes wrong in one area, it can very quickly impact the other. But the good news is, like we've learned with the right guidance, understanding, and awareness, that most of these issues are preventable. We will have more information about Amell Law Firm linked below in the description so you can learn more about JJ and the work that his firm does. Be sure to subscribe to Know Your Regulator so you never miss an episode or an update about the rules and regulations impacting your professional license. Until next week, stay inspired and continue engaging with your regulatory agency. Thank you, guys.
Thank you for having
Thank you,
me.
Simone.
Know Your Regulator, the podcast that inspires you to engage.